Well, thank you, John, and thank you all very much indeed for having me back to the University of Sydney. I was rather disappointed actually as I came through the quadrangle to realise the jacaranda tree is gone, but I think there's a new one planted, so hopefully that will bring that beautiful blue that always reminds us that the exams are on the way. It always terrified me. John has actually very kindly introduced me, and introduced me indeed as an emeritus professor of international law, which I am from the University of Sydney. I'm very grateful for it. But I was introduced a few weeks ago as my term as the President of the Human Rights Commission came to an end as Emeritus Professor Gillian Triggs, emeritus being Latin for has-been. Well, I'm not quite a has-been, and one of the nice things about having finished that position is that I've now got the luxury to move on to some areas that really do interest me as a public international lawyer, and where I hope that I can add something to the debate and discussion tonight. It's a huge pleasure for me to be with Paul and Kelly and John, and to be with all of you. So, but let me begin then by just reminding us of where we are today. The recent announcement by the Foreign Minister of military assistance to the Philippine government in combating the so-called Muslim insurgency in Mindanao has raised yet again the wisdom of maintaining the almost unchecked power of Australia's executive government to authorise military engagements. The agreement to provide President Duterte with SAS units to advise and to assist, along with providing 2 AP-3C Orion surveillance aircraft, those decisions have been made in the absence of any form of transparency or federal parliamentary consultation. There's been almost no explanation as to why, after decades of separatist fighting in Mindanao, military assistance is now given to the President, who's notoriously ordered the extrajudicial executions of thousands of his own citizens in a war against drugs. He suspended habeas corpus, and he's basically suspended the rule of law throughout the area in southern Philippines. There is, of course, nothing unusual about the unilateral decision by respective Australian governments to deploy armed forces or to provide some form of military assistance in international conflicts. Over many decades, our Prime Ministers have announced such engagements only subsequently to inform Parliament. Vietnam, Afghanistan, Iraq. Australia has a long-standing military support for the Syrian bombing campaign and continued deployment of military personnel in Iraq, with little or no public discussion or parliamentary debate. Well, with this informed audience, I won't revisit the constitutional questions of the defence power, nor its purposive interpretation by the High Court, other than to observe the troubling fact that the power to make war is an almost unconstrained executive function in which Parliament has no formal role, a situation that I believe is out of step with contemporary practice of other comparable governments and with the principles of the rule of law and good governance generally. Well, what can I add to a discussion such as this about the reform of Australia's war powers? My perspective on this issue is informed by my career as a public international lawyer, but most especially as President of the Australian Human Rights Commission over the last 5 years. It's become clear to me that quite apart from the defence power itself, the federal executive has expanded significantly over the last 10 to 15 years, not only to the detriment of parliamentary processes, but to the detriment of the independence of the judiciary and the separation of powers among the 3 branches of representative democracy. With each new piece of legislation, we have found the federal executive augments its discretionary power with little resistance from Parliament, the courts or the public. Examples include, of course, the, in my view, disproportionate counter-terrorist legislation, the rise of non-compellable and non-reviewable ministerial discretions, the use of control orders, the implementation of laws for the retention of metadata and indeed the access to metadata laws, or to metadata information, the cancellation of citizenship where there's a dual citizenship, and visa cancellations on character grounds, leading to rising numbers of people in mandatory detention in our detention centres. laws to arrest bikies, to detain sex offenders and violent offenders, all without trial, and of course the continued use of mandatory detention without trial and offshore processing. In all of these ways, the federal executive augments these powers with very little control by the courts for very particular Australian reasons of exceptionalism and isolation from the principles of the rule of law, of international law, and of human rights law generally. The executive overreach through disproportionate laws has been largely unremarked even by the media, allowing respective governments to assume virtually untrammeled discretion in dealing with alleged risks to national security. In stating my concerns about the executive war powers, you might reasonably, however, point out that the power of the executive is always subject to the will of Parliament and ultimately to the ballot box. Under the Westminster system, if members of Parliament are unhappy with the unilateral decision of the government of the day, the Prime Minister and the ministers are subject to scrutiny at question time, and the government may be subject to a motion of no confidence. In short, perhaps one should not exaggerate the dangers to democracy and executive war powers because the checks and the balances are in place. Well, I respectfully contest that sanguine view. Questions of national security and political manipulation, in particular the fear of terrorism, often conflated with the fear of unauthorised arrivals of immigrants, asylum seekers and refugees, even a confected fear of Islam itself, have shielded government measures from political challenge or rigorous scrutiny. It's become almost a taboo subject, creating a vacuum of silence in the absence of strong leadership. Well, I suggest that the justifications for tolerating a wide defence power, especially the alleged need to respond urgently, are often specious, as the logics for such deployment take many months. Most particularly, unilateral decision-making fails to raise or to answer the very important questions. How is it that this most crucial decision to engage in international conflicts should be made without the safeguards of contemporary democracy, of transparency, access to accurate information, public debate, and compliance with the rule of law? What national interests are being served by international military engagement? Are Australia's international obligations under the United Nations Charter being observed? Will the military engagement comply with international humanitarian laws, especially where bombing campaigns indiscriminately kill predominantly civilians? What are the expected outcomes of the military deployment, and how will these be assessed? What are the time limits, and is it possible to control the slippery slope of lengthy engagement? What programs are in place to deal with the aftermath of conflict, to rebuild a damaged civil society, and to ensure good governance and the rule of law? Well, it's long recognised as a cliché that the first casualty of war is truth. But only last year did the Oxford Dictionary include the term post-truth as the word of the year. The idea that there are alternative facts and that they too have credibility has created an Alice in Wonderland world where words mean what we choose them to mean, or as George Orwell so wisely wrote in 1984, what the party says is truth is truth. All this might be of interest only to scholars or to close political observers, were it not for the dangerous times in which we live and the severe human, predominantly civilian cost of all military deployments. We've seen the rise of ISIS in Iraq and Syria, renewed US commitment to the conflict in Afghanistan. We've seen the rise of homegrown terrorists in the United States, in Europe, in the United Kingdom, and in Australia. In the Asian region, we've seen threats to stability over the South China Sea, the brutality of treatment of the Rohingya from Myanmar, with UN officials now fearing crimes against humanity. And we've seen the missile launches and threats by North Korea and concerns about Muslim or terrorist insurgencies in Mindanao. Compounding this dangerous cocktail of instability is the phenomenon of weak and inexperienced global and national leadership. We watch with horror as the traditional language of diplomacy, restraint, and the international rule of law at the United Nations has been replaced by the United States President's use of the language of brute force and threats of total destruction. Well, being invited to take part in this International Day of Peace, I'm reminded of my own disillusionment at the decision of the Howard government to join the coalition of the willing of Iraq in 2003. My concern at the time was less the failure to have credible evidence that Saddam Hussein possessed weapons of mass destruction, for how could I possibly judge or know? But rather, it was the cynical and opportunistic disregard for international law and the processes of the United Nations Security Council that prompted my public condemnation of Australia's contribution to the war. Indeed, looking back and thinking about this, what I was going to say tonight, looking back, I remember how extraordinary it was for me, although I was at university in the 60s and marched behind Jim Cairns in the moratorium marches in Melbourne down to Treasury Gardens and listened to him speak. I didn't really know what it was all about, but by the time we came to the second war in the coalition of the willing in Iraq in 2003, I really did have some expertise in international law, and I found myself doing something which I shudder to think about now, standing on the steps of the Supreme Court of Victoria with a microphone in my hand, talking about the failure to abide by well-established principles of the United Nations. So it certainly has brought back some of those memories, and who could have known at the time the disastrous global and regional consequences of that illegal intervention. But it had, at that time, cemented my commitment to an international rules-based regime to prohibit the use of force and to manage conflict. International law has informed my entire legal career. As a young law student, I was inspired by the aspirations of the Covenant of the League of Nations after World War I, the war to end all wars, and the Charter of the United Nations after World War II, to employ the law to regulate and, if possible, to prohibit or limit war and conflict in all its forms. I was so stimulated and excited by the work that Doc Evatt did in the United Nations in drafting the Charter in part and accepting the invitation of Eleanor Roosevelt to draft the Universal Declaration of Human Rights in 1948. It's perhaps not always remembered what a remarkable man Doc Evatt was on these questions, with extraordinary vision and foresight. And he was, of course, the President of the General Assembly when the Universal Declaration passed without a single negative vote in 1948. His sheer force of personality, brilliance as a lawyer, and absolute determination that this document should be the platform for the development of all modern international human rights law is really quite remarkable and often forgotten, and sadly, I think, now betrayed. Well, Australia has been a party, of course, to the UN Charter since 1945, and its preamble says that the UN was established to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind. The armed force shall not be used save in the common interest. Under the framework of international law, the use of force was for the first time fully prohibited. The Charter provides that all nations shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. That cardinal principle has only two exceptions. Nations can go to war where this is authorised by the Security Council or where there is an act of self-defence. So it was in light of these clear and agreed rules that it was astonishing for me that the federal politicians, lawyers, diplomats and civil servants could at the time of the Iraq invasion argue what I knew to be categorically legally wrong. In essence, and you might remember all of these detailed arguments, the argument made was that Security Council Resolution 678 gave the UN members an implied right to use all necessary means to restore international peace and security in Kuwait. It was alleged that resolution was revived 12 years later on the alleged material breach of another resolution, 687, by Iraq of a ceasefire resolution in 2002. The argument was completely fallacious. There is no implied right, and there was no way that a resolution in relation to Kuwait could be revived 12 years later to justify military action in Iraq. There was no right of individual state action. The Security Council was properly seized of the matter, and it alone was empowered to take action. Well, I think you all know the outcome, and you'll also be aware of the Chilcot inquiry in 2016. The Chilcot inquiry took 7 years to complete, and it looked, of course, at British conduct of the war in Iraq. And it made some very important findings. That the coalition of the willing was based on tenuous evidence, some of which proved to be pure fabrication. The British government had ignored contrary evidence or had downplayed any contrary evidence. Intelligence was gathered by the agencies with the aim of supporting the already agreed political policy view, rather than providing an objective assessment of the threats to peace and security. And the Attorney General, then, Lord Goldsmith, was persuaded, as you'll all remember quite dramatically, to modify his original legal opinion after making a visit to the United States State Department. Well, Australia, to our shame, was provided with extremely poor legal advice by the Department of Foreign Affairs lawyers, advice that largely mirrored that of Lord Goldsmith, which in turn mirrored the views of the United States government. Little attempt was made by our senior civil servants to provide fearless advice to the government, but maybe they'd learned from the experience of Lord Goldsmith. Well, since 2003, over those 14 years, I've learned many lessons. And one is the failure by Australia to implement its international obligations in our national laws, so that Parliament and the courts have been able to discount international law in favour of the Constitution and the unambiguous and clear language of legislation. And we find that point made over and over again. Perhaps don't need to remind you that we are the only democratic country in the world that does not have a Bill of Rights. We are the only common law country in the world that does not have a Bill of Rights. We do not have the constitutional protections that would provide guidance to the court or even to Parliament. This has led to the relative isolation and exceptionalism of Australia with respect to human rights, to the mass movements of peoples and refugees, and even to global environmental challenges. But the other lesson, and it's a broad one, has been, as a consequence of the growing isolation of Australia from jurisprudence, an increasing expansion, as I've said, of executive discretionary power. So that when I come to the question of war powers, I tend to see this issue within the much broader canvas of encroaching, overreaching power of the executive and ministerial discretion that is not for practical purposes subject to judicial review, as being one of the greatest dangers to our contemporary democracy. And it's for those reasons, and I've thought quite a lot about this, is that I've come to the view that we do need to strengthen the role of Parliament in a stronger advisory role, particularly through its committee processes. We need a broadening of the role of Parliament, and I should have thought some form of inquiry into Australia's role in Iraq, although that clearly has fallen on deaf ears. Just very briefly, Australia's constitution vests the power of decision-making with the Queen in conference with the Governor-General, who in turn acts on the advice of the Prime Minister and the Federal Executive Council, comprising all the ministers and parliamentary secretaries. The Constitution provides an executive power to make decisions for the execution and maintenance of the Constitution, and the executive power can, however, be limited and regulated by Parliament, because Parliament is specifically given the legislative power to make laws with respect to naval and military defence of the Commonwealth and control of the forces. And indeed, the High Court, Justice Isaacs in Ferry and Burnett, has particularly emphasised the importance of Parliament in advising the executive on the use of the defence power. But in recommending a stronger parliamentary role in any decision to use military force internationally, I do so with some profound reluctance. That is because the current parliamentary committee system is very weak and often ineffectual. The respective committees all too frequently vote along party political lines, thereby reducing the credibility and power of their reports. The recent work of the Human Rights Scrutiny Committee and the Security and Intelligence Committees are disappointing examples. Moreover, even a considered report will often be ignored during the debate on a bill on the floor of the House, or lost in the deal-making with independent senators. It's also true that Parliament itself has been weakened over recent years, and there's been a tendency for oppositions, particularly with regard to anything labelled as terrorism or national security, a tendency for Parliament not to engage in any kind of really rigorous scrutiny of measures that are being proposed by the government of the day. So that the role of opposition within Parliament does seem to me to have been significantly weakened in an attempt to ensure that there's no daylight between the government in power and the opposition on issues of national security and terrorism. But with all of these defects, which I believe to be true, there's nonetheless a phenomenon, I think, in Australia, that we have a strong preference for parliamentary decision-making above judicial supervision. Now, I have no difficulty with the concept of judicial supervision. That's how Europe, North America, New Zealand, Canada operate, where they have bills of rights and constitutional provisions which provide benchmarks for judicial control over the executive. But that is not working in Australia, and at a political level, I have to accept that we're not really going to, there's almost no political support, for example, for a Bill of Rights in Australia. It is curious, given that I've said we have a preference for parliamentary decision-making, that we have the lamentable exception of the postal vote on marriage equality, but putting that to one side, we do seem to have a political preference to work within the parliamentary system. And that is why I suggest that we do need to strengthen some form of advisory and consultative rights of a parliamentary committee. It may be that we could go so far as to ensure that any decision to go to war should be made by a joint sitting of both houses to allow the government to gain the outcome it wishes, with its greater majority in the lower house likely offsetting its deficit in the Senate. While the Prime Minister's war powers will be subjected to new checks and balances and greater deliberation, it would, in most cases, still enable the government to determine the course for which it ultimately will have to answer at the ballot box. Well, I believe that we should have had an inquiry into our engagement with the coalition of the willing. We should have been able to learn from that experience, as indeed the British have done. But at least we should not forget the events of 2003, and I really do support this initiative and the discussion for reform of these powers, because I think it's time that we looked at an evolving trend amongst comparable legal systems to engage Parliament more closely, not necessarily with a decision-making power, although I think that would be preferable, but at least to engage in a public discussion about the need for a more contemporary approach to public discussion and query about the resort to military engagement, in particularly, of course, as we're likely to see it more within our own region. These are very dangerous times, and I think it's important that we remember both the principles that Doc Emmett fought for, the principles indeed that I think we fought 2 wars for, should be upheld and respected, rather than ignored as they typically are within Parliament and by our parliamentary leaders. So I very much look forward to the following discussion, and thank you all very much.